Okay, welcome everyone. Hello, hi, thank you for joining us. It's a pleasure to see you and welcome as well to those that are joining virtually. This is a hybrid event, so we have lots of people joining us online as well, and welcome to all. For those who don't know me, my name is Colin Pachaco. I'm an associate professor here at Osgoode, as well as an executive member of the Nathanson Center on Transnational Human Rights, Crime, and Security. And in that capacity, I'm just delighted to welcome you on behalf of myself and the Nathanson Center director, my colleague, Professor Barnali Chowdhury, who has had to send her regrets, like a number of people has had to send regrets today for being under the weather, which is of course understandable in this current era and season. Please, if you are in person, help yourself to food and don't hesitate to get up, especially during my remarks, if you'd like to grab yourself a coffee or a sandwich. Before I formally open the event, I just wanted to give you a couple of notes about how we're going to proceed. Professor Aziz Huq will, of course, give us a talk on his paper, and then we will have ample time for audience Q&A. If you are joining us virtually, you can type your questions into the chat function directly to me, Colin Pachaco, the host, and I will read your questions out during the Q&A. I want to thank Liel Gonzalez, our research center director, for all of her efforts. We certainly could not manage any events without her. I also wanted to mention that the session is being recorded today. All right, before I formally introduce our speaker, I just want to take a moment, as is our practice at Osgoode and at the Nathanson Center, to acknowledge the land where we are located today. As you'll know, if you've read Professor Huq's brilliant paper that this talk is going to be about, or even just from the title of the talk, today we're going to be discussing issues in the virtual world. And of course, as we know, there's all kinds of challenging issues of law and governance that come up in the virtual space that's not bounded by traditional notions of jurisdiction or geography. But as we read his work, or as we sit and have this conversation, each of us is necessarily an embodied person in a space, and there's significance to where we're located. And it is significant that today we are located, for those of us who are on or near the York campus, in the area known as Takaranto. And there are, of course, particular opportunities and responsibilities that come with doing this work where we are. And so it is in that spirit that we acknowledge that York University is located on the traditional territory of many Indigenous nations. The area known as Takaranto has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat, and is now home to many First Nation, Inuit, and Métis communities. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation, and we note that this territory is subject to the Dish with One Spoon Wampum Belt Covenant, which is an agreement to peaceably share and care for the Great Lakes region. So now I have the distinct pleasure and honor of introducing our speaker, Professor Aziz Huq. He is the Frank and Bernice J. Greenberg Professor of Law at the University of Chicago Law School, where he's a scholar of US and comparative constitutional law. His award-winning scholarship has been published in leading law reviews, social science and political science journals, as well as in books. His most recent book, The Collapse of Constitutional Remedies, was published by Oxford University Press last year in 2021. He's also written for media outlets and other non-specialist publications, including the Washington Post and the New York Times. He has an active pro bono practice and is on the board of the American Constitution Society, the New Press, and the ACLU of Illinois. He holds degrees from the University of North Carolina at Chapel Hill, from which he graduated summa cum laude, as well as from Columbia Law School, where he graduated first in the class. He clerked for Judge Robert D. Sack at the U.S. Court of Appeals for the Second Circuit, and then for Justice Ruth Bader Ginsburg at the Supreme Court of the United States. Before joining Chicago's faculty, he worked as counsel and then as director at the Brennan Center's Liberty and National Security Project. He's also worked as a senior consultant analyst for the International Crisis Group. He's been a visiting or adjunct professor of law at the NYU School of Law and Stanford Law School, and he's expected to return to Toronto in the new year to take up a visiting professorship with our neighbors at the UT Faculty of Law. And just on a personal note, I've really long admired Professor Huq's scholarship, among other things, for the way in which he's able to, I think, identify and clearly articulate really bracingly current and material questions and issues, and then come at them in a way that is just so deeply embedded in and enriched by philosophical and theoretical literatures. It's really just a pleasure to read his work and a pleasure to have him with us today. So Professor Huq, thank you so much.
So I hope it's okay. I'm going to remove my mask to talk, especially if people are online. It's hard to hear otherwise. Thank you so much, Anna, for that very, very kind introduction. And don't see here, but thanks to Leo for organizing the logistics of this visit. I especially appreciate the land recognition, which is something that is not normal, has not become a currency in US law schools, but it's certainly something that I happen to have been teaching property law for the last couple of years, have become much more aware of, and very much hope becomes a practice in the US. So I'm delighted to be with you today. Thank you so much for hosting me and talking to you about a paper. The paper, let me say first a bit about the context of the paper. The paper is going to be appearing in a symposium that the Emory Law Journal is running. The symposium is largely on First Amendment issues, and this will become clear. I have cut against the grain of the symposium by essentially writing about a First Amendment issue, the US First Amendment, as if the First Amendment didn't exist. The project, though, is feeding into a larger body of work that I'm engaged in, which is a series of pieces about the ways in which the emergence of new computational technologies, in particular what's called machine learning, shape our experience of power, and whether the fundamental human rights that have developed over the last 60 or 70 years as ways of navigating or negotiating power need to be changed or need to be rethought as we move from a world in which power is not being exercised at the tip of the spear by human beings, but by machines and by algorithms. And it's a project that draws upon earlier work about algorithmic sentencing in the criminal justice context, a piece that draws upon the idea of what counts as a hearing, what counts as due process in a world in which machines are going to be the ones making decisions in many cases. And then this paper is about speech, and in particular about the role that public and private actors play with respect to speech in a world in which, to a certain extent, speech controls are technologically focused. So the paper very much has a local home in the Emory Law Journal, but it is feeding into this bigger project that will be a book, I hope, called Rights Against the Machine, which may be a joke that only people who grew up in the 80s will get. It's just like two people laugh. That's right. Exactly. I'm like totally dating myself with the title.
The first album is from 91.
There we go. All right, good. Okay, good. Okay, it's like Okuron enough that it works. But the aim of this article is to feed into that chapter in that book. Okay, so what is the paper about? So the paper starts out with an empirical premise. This is the premise that social media platforms such as Twitter and Facebook are both now essential to the functioning of democracies, national level self-rule, but also, and by design, imposing serious harms on the quality of democracy. There are two main mechanisms through which social media imposes specifically democratic harms. The first is there's evidence that social media drives polarization, drives the existential divisions in a society. And then second, social media is identified as both a source and a potent distribution mechanism for misinformation, particularly misinformation in the public sphere. The key empirical premise of the project is that these are substantial problems that are distinctively raised by social media. It's not the case, clearly, that polarization or misinformation are new problems. It's not the case that older media forms, such as print or broadcast, did not implicate either of those two phenomena that put pressure on democracy. But the premise of the analysis, the starting point, which I don't try and defend in the paper, except by reference to other people's work, is that there is an empirical case for thinking that social media is imposing novel strains, at least in magnitude, if not in kind, on democracy. And obviously this is a particular concern in the United States. So what then is to be done? In the United States, the question of social media's role in a democracy is analyzed principally through the First Amendment to the US Constitution. And the First Amendment to the US Constitution makes a certain set of questions key. So among those questions are first, are platforms a form of state action such that they fall within the rubric of the First Amendment, or do not fall within the rubric of the First Amendment? Second, are they publishers? Publishers obtain a certain set of privileges under the First Amendment that other actors do not. The question of what counts as a publisher or not is the question that's at issue in the legal challenges to the Texas and Florida social media laws that are now proceeding through the lower federal courts in the United States. The Florida law has been enjoined and is currently not being implemented because of the 11th Circuit opinion, 11th Circuit Court of Appeals. In contrast, the Texas law, at least at present, has been upheld by the 5th Circuit Court of Appeals. And the key question there is the platform a publisher for the purposes of First Amendment doctrine? The further question that the First Amendment requires a lawyer or a judge to ask herself is the regulation at stake content neutral? Does it distinguish on the basis of content? Now, I am not convinced that this suite of questions, who's a state actor, who's a publisher, and then what is or is not content-based regulation, cuts to the heart of the challenges that are presented by social media to democratic norms. In many ways, they're slightly at an angle to the difficult problem of whether social media is indeed essential to, or whether it is undermining fatally a democracy. So the project of the paper is to ask, is there a different analytic frame that we can use to approach the question of social media in relation to democracy? Is there another way of thinking about the problem that more acutely or accurately picks out the salient features either of the platforms themselves or alternatively the regulators in a way that gives us traction on that problem? And the answer that the paper tries to work through is to say, well, there is a set of intellectual resources that now date back almost a century that we can look to as a way of thinking about this problem. There's a set of resources that give us a set of tools for thinking about the problem. It is a set of resources that was initiated by a German emigre to the United States. He fled Germany in the 1930s and found a berth at Columbia University in their political science department. His name was Carl Lowenstein. And in, I think it was 1934, Lowenstein published 2 articles in the American Political Science Review on what he called militant democracy. Militant democracy was a theory of how states could defend themselves better against the threat of democratic backsliding, at least better than Germany had done in the early 1930s. And the particular concern that Lowenstein brought to the table was with the phenomena of political parties that presented an existential threat to democracy. Obviously, the Nazi Party in Germany was the core case that he had in mind. But here's the reason for thinking that the militant democratic framework is one that is salient today. Militant democracy was a way of identifying and grappling with the problem of regulating entities that were simultaneously necessary to the good functioning of democracy and potentially fatal to that good functioning of democracy. In Lowenstein's time, political parties were, as they are now, necessary to the operation of a democracy. And yet, in their dysfunctional form, political parties, as the Nazi Party was, as Mussolini's fascist party was, could also be fatal to a democracy. They were a double-edged sword, both necessary and potentially deeply damaging. Social media platforms have the same structural quality. At least today, they play a necessary role in disseminating and allowing access to information on the part of many citizens who participate in a democracy. At the same time, because of the manner in which they are designed to maximize engagement, social media platforms have polarization and disinformation effects that are at least serious shadows upon the quality of democracy, at least potentially. So given that analogy, does the language and the theory of militant democracy give us a foothold to start thinking about how we go about regulating social media? So Lowenstein's particular solutions were varied. So at the core of them was the idea that certain political parties could be banned. Another element was the idea that there would be legal prohibitions enforced by the criminal law on paramilitary action, right? Forming quasi-statal armed groups and carrying a party uniform. Proposed a ban on party uniforms. He proposed a ban on extremist candidates in parliament, a criminal prohibition on agitation of certain kinds, particularly that aimed at religious or racial hatred, and then a prohibition on any public propaganda by subversive movements. Right? At least under the terms of the US's First Amendment, almost all of that is simply off the table a priori. Lowenstein's theory was influential, not so much in the 1930s when he wrote it, but as a consequence of the decision of the drafters of the German Constitution, the German Basic Law of 1949, to include elements of militant democracy in their model of in their constitutional model. I'm sorry, I just went over a page. I apologize. I have lost a page, which I should be fine, but there'll be a moment where I'm making stuff up. The most important element of the militant democracy model that, there it is. The most important element of the militant democracy model that Lowenstein proposed that was adopted into the German Basic Law in Article 21 was the party ban provision. The party ban provision prevents parties that are extremist The exact language of that provision is that parties that by reason of their aims or the behavior of their adherents seek to undermine or abolish the free democratic basic order or to endanger the essence of the Federal Republic of Germany shall be unconstitutional. Parties are also required to have a democratic internal structure, and these provisions are enforced by the German Constitutional Court. Indeed, in the 1950s, two parties, a successor party to the National Socialists and the Communist Party, were banned under Article 21. There was recently an effort to have the Alliance for Germany, AfD, banned under that provision too. The reason that one reason that the militant democracy frame is so fruitful, I think, is that the German model in Article 21 became a template for many other jurisdictions that have adopted either party bans or related measures proposed by Lowenstein as a means of defending their democracies against extremist parties. And it's not to say that these measures have been uncontroversial, quite the contrary. From the very first years in which Lowenstein wrote, there has been a vigorous debate about whether these measures are wise, moral, or even consistent with democracy. So, for example, one of Lowenstein's very first interlocutors was the famous Austrian jurist, the founder of their constitutional court, Hans Kelsen. And Kelsen argued that it was simply an oxymoron for a democracy to use anti-democratic tools in order to perpetuate itself. He said that cannot be done, and so it's categorically impermissible. One of the real benefits of thinking about the platform problem through the lens of militant democracy is that we can benefit from now almost a century of really serious, interesting analysis and thought on when and how a militant democracy scheme will work and when and how it will be dysfunctional. Indeed, in earlier work, a book that I co-wrote with Tom Ginsberg, my colleague, we looked at the range of militant democracy measures in Europe that were focused upon parties, and we actually were pretty skeptical that militant democracy was going to work against the populist wave in Europe. But that's part of that debate. One of the things the paper tries to do is to take that quite unruly debate that's occurring somewhat in law reviews, but actually largely in the political science literature, and try and tame it, try and bring it to bear or bring it into relation with what's known empirically about the practice of militant democracy since 1949, and say, look, here's what we've learned. Here's what we've learned about the theoretical tensions. Here's what we've learned about the way that these measures work out in practice. And given that learning, here's what we might take away from 70 years of theory and practice on militant democracy for the purpose of thinking about platforms. What I want to do in the balance of time that I have is to work through 5 different lessons that I think that we can draw from that literature, right? And just to be clear again about the point, the idea is to say, if we were to take militant democracy as our frame of reference for thinking about the problem of regulating social media platforms for the purpose of advancing a democracy or the quality of democracy, what lessons do we learn from that theory and practice of 70 years? Okay, that's the project of the paper, just to be very clear. And there are 5 things I think that I want to draw out from that earlier literature. And I want to be very explicit that I am trying here to triage wisdom that's not mine, wisdom that comes from many other authors, and bring it to focus on a context in which I think it has been largely ignored. And I would emphasize that the reason it's ignored in the US legal context in particular is the hegemonic force of the First Amendment. The First Amendment puts off the table most militant democratic measures. Therefore, nobody in the US reads the literature on militant democracy, let alone learns lessons from it. So part of the big project here is to say, hey, you guys, all of these problems that you're analyzing through the lens of the First Amendment, there are other ways of thinking about the problem, and there are lessons that you can learn from it. Okay, with that recapitulation of what I think the broad point is, here are the 5 points that I would draw out from the militant democracy literature. So the first is simple. The regulation of platforms in defense of the democracy inevitably involves trade-offs between compelling ethical commitments. There is no such thing as a sensible approach to the problem of democratic regulation of social media that is absolutist in character, that does not require giving up along some margin. Now, I think that this is a point that has its most resonance in the United States, where there is a constituency, particularly in the legal academy, that is absolutist with respect to speech values, absolutist with respect to when and how the government can impinge upon speech. I don't think that it makes much sense to approach the problem of social media in relation to democracy, let alone the problem of parties that have this two-sided quality with respect to being essential but also being potentially quite damaging to a democracy. I don't think it makes sense to approach these problems without at the start recognizing that there are trade-offs that one has to make and one has to focus on and think about what those trade-offs are. A kind of correlative point to that is a central tool that the US First Amendment doctrine brings to bear in thinking about what government regulation is or is not permissible is the idea of content neutrality versus content sensitivity, right? A content neutral regulation is more likely to be upheld by a US court as opposed to a context dependent one, on the theory that if the regulation is selecting on the basis of content or viewpoint, although that's a more serious constitutional problem, it is more likely to be constitutionally offensive. That framework for thinking about the speech problem in the context of social media, I think does little work. An effectual regulation of social media will be content dependent. The whole point of regulating social media is to maximize beneficial speech and to minimize harmful speech. That's going to require drawing content-based lines, right? So the focus upon content neutrality in the US First Amendment doctrine, I think, is not, which comes, I think, from a commitment to absolutism, I think is not a helpful starting point. Second, the militant democracy literature teaches us that a particular problem in regulating these two-sided, two-faced threats is a problem of time. There is, I'll use a fancy Latin word, an intertemporal problem with respect to this regulation. Here's the gist of it, which I think once I explain it, it will be pretty straightforward. So at an early point in time, there's a platform or a party, and regulating that entity is relatively straightforward. It's small, therefore regulating them does not impose large harms or distortions or repercussions to the wider speech market. Regulating them doesn't require a great deal of political capital. It's unlikely that that entity will be able to block, either through its political power or its economic power, effectual regulation. And the coalition that's necessary to enact something into law, in the legislative context at least, is going to be more likely to be amenable to creation. It's going to be easier to put together that coalition, right? So early in time, when something is small, when an entity is small, regulation, the costs of regulation, all things considered, are going to be lower. But notice that that's at a moment in time at which the threat that's posed by the platform or the party, it's not terribly significant, right? Facebook, 1999, whatever it was. As time goes on, as the costs imposed by the platform or the political party that's both essential to and imposing costs on the quality of democracy, as time goes on and that threat gets more serious, the costs of regulating it also go up. And those costs, I think, play out in a number of different ways. The first cost is as the party or the platform gets bigger, you regulate it, and the potential for unexpected repercussions for the operation of democracy gets larger. It just becomes less predictable what a regulatory intervention will do. Second, it will become more difficult over time, all else being equal, to construct the necessary legislative coalition to regulate that entity, right? It is much more difficult to regulate in the United States Facebook today than it was 15 years ago, because Facebook has lots of allies in Congress, right? So the success of the platform or party makes it more politically difficult to regulate. Further, if by assumption, the presence and the growth of this party or platform is having negative externalities on the quality of a democracy, the longer you let that party or platform grow, the more of a decline you've had in the quality of a democracy, the harder it's going to be to regulate well, and the greater the risk that the regulation will not be focused upon advancing the shared interest in democracy, but will be focused upon some other potentially anti-democratic entrenching goal. I think that that is illustrated by both the Florida and the Texas social media laws. In both cases, those state statutes are justified on the ground that Facebook in particular is biased against conservative speech. The speech in the signing ceremony for the Texas law, Governor Greg Abbott talked about leftist social media. Those are laws that are animated not by an aim of improving democracy, but by an aim of enlarging the political space for one, but not the other side of the political spectrum. And they're enacted by state coalitions that are on the conservative side. So the risk of measures that do more harm than good, democracy goes up as the entity gets bigger. So there's a paradox or an intertemporal difficulty. Paradox is too strong a word. It's easiest to regulate when the need is least. It's most difficult to regulate for a multiplicity of reasons when the need is most pressing, right? That's a lesson from the literature on militant democracy. Okay, third. One of the critiques that's made of the militant democracy literature is that the kind of interventions that Lowenstein proposed were superficial. They targeted the symptoms of democratic decay, but not the underlying causes. A lesson that we can draw from the literature after Lowenstein is that regulators have to be really thoughtful about what the relationship is between the actual mechanisms through which democratic quality declines and the underlying mechanisms that are driving it. Now, in some instances, doing nothing about the underlying mechanisms but addressing the symptoms will be ineffective. But in other cases, addressing the symptoms buys you enough time to address some of the underlying causes, right? And there's no magic formula that tells you which world you're in. The designer of the regulation has to make a judgment as to whether, by addressing the symptoms of some deeper pathology in a democracy, they are indeed advancing the ball or not. But that question is not one that the First Amendment literature tees up. It is one that is teed up in the militant democracy literature. Fourth, one of the ways in which militant democracy measures have changed over time is that they have gone from being relatively coarse, ban all parties, ban all uniforms, ban all paramilitary groups, to being relatively fine-grained. So for example, I think the best example of just kind of fine-grained measures come from Germany and Israel, where the law not only allows, in certain instances, in Germany it allows for party bans, but the law has moved to focus upon party funding as a mechanism that the state can pull and tweak in ways that push against anti-democratic parties. Right? So the idea is that over time, militant democracy measures have become more finely tailored. Tom Ginsberg, David Landau, and I have a forthcoming paper that looks globally at disqualification or lustration rules that exclude a given person from political power or from holding political office. And we show something similar there. We show that there's been a development and a refinement of lustration regimes over time. I think an important lesson for militant democracy is that you should figure out ways of refining the instruments of militant democracy in ways that maximally respect the rights of even those co-citizens that we treat as unreasonable. Being unreasonable in a kind of thick democratic sense does not put you outside the democratic pale. And there are ways of implementing militant democracy that respect even the rights of those who are unreasonably unwilling to respect the rights of others. So notice one way in which that pushes. One way it pushes is toward regulation by the platforms themselves, rather than by the government. Platforms can do a lot that is much more tailored than government can do, right? They can tweak their algorithms, they can ban particular people, they can have short bans or long bans, they can have conditional bans, lots of stuff that platforms can do. Maybe they won't do it, but it is a reason on the ledger on the side of the platform rather than the government acting. Okay, fifth and final thing. A central axis in the debate about militant democracy is the nature of the institution that does the regulating. For example, lustration regimes started off being run by courts, and it turned out that courts were not particularly willing to disqualify people. This is true in the Central European experience in particular. And so the lustration regime shifted over to administrative agencies. And it turned out that they were more aggressively applied, but actually applied in ways that were reasonably warranted. They were justified applications. Thinking about the institutional qualities of the regulator turns out to be really important. And a comparative analysis of the strengths of the various regulators ought to account not just for the possibility of different actors within government, but also a comparison between governmental actors, and this goes back to my last point, and the possibility of self-regulation by the platforms themselves. That is not to say that self-regulation is always the answer. There is the example of the Facebook Oversight Board, which is generally has received a fairly warm welcome in the, at least in the US law literature. I tend to be a bit more skeptical of the board and its capabilities than the US literature is, but it is an interesting and challenging model, right? The possibility that it might be possible to create the kind of decisional autonomy, independence, and non-partisanship within the structure of the corporation than it is within the structure of the state, right? That design question, right, which in comparative statics terms is the optimal location for regulation in a militant democratic vein, has been extensively studied in the militant democracy literature. It doesn't get much attention in the First Amendment literature. It doesn't. The First Amendment is famously insensitive with respect to whether the regulator is the federal government or the states. The same First Amendment applies to both national government and subnational governments. Doesn't really make that much difference whether it's an agency or the Congress doing it. It's not clear that that should be the right approach, right? And the militant democracy approach suggests we ought to be, first of all, thinking about comparatively what are the strengths and weaknesses of different regulators, and then evaluating regulation by that entity with those strengths and weaknesses in mind. So I'm going to wrap up now. I want to be clear, just in wrapping up, that it's not that I think that these 5 guideposts give us a kind of recipe for addressing the real, I think, problems for democracy that social media presents. Rather, what they do is they set the field for thinking about what that regulation might look like and how best it might proceed. I think that the last point that I would make is that I think that many of the sort of the broad themes of those 5 points that I've just made, which are be sensitive to social and economic context, think about and tailor regulatory interventions in light of the relative competence of the available regulator, and keep an eye both on the costs and the benefits of regulation, not just for speech per se, but for the goals that speech is meant to pursue, I think are not terribly controversial. I don't think that they're I don't think that they break new ground in terms of their insight. But I do think that they are values that are singularly lacking or fall to the wayside, at least in the American debates about social media and its regulation, in part because of the First Amendment lens that's applied. But I would be delighted I know criminally little about the Canadian approach. I'd be delighted to hear about it and be delighted to be told that you guys do it better than the US, although it's not saying very much. Thanks.
Well, thank you very much. I think I'm going to stand up and walk over with my laptop. I'm sensitive to trying to make sure I hear reasonably. Oh, now I'm like visually broadcasting myself walking, which is not my intention. Hello to everyone at home, but I'm going to stand so that I'm a little bit more, I think, audible, and I will moderate the questions. Just a reminder that if you are one of the people that just was watching me walk in close up from home, you can send your questions directly to me through the Q&A function, and I'll share them with Professor Huq, and I can also take, of course, questions and comments from those in the room. Please go ahead. And oh, just one quick thing is, if you could introduce yourself, since we don't all know Professor Huq, when you ask your question, just so we know how you're affiliated with Osgood or Nathanson, that would be terrific. Thank you.
Hi, thank you so much for that. So my name's Lauren. I'm a second year JD student. And I was just wondering, so like first stab at this, a potential solution would be to ban all shared content on social media, like without any external links in terms of like memes or like to non-credible news sources, but it would just be blanket. So social media, like, so then you would not target someone just saying their political opinion, but they can't spread fake news, misinformation to the same level. And I'm wondering, like that shot in the dark solution I'm coming up with in this moment, like would that still have a conflict with free speech? Because it's not banning the individual speech, it's just banning the sharing of external speech.
So I'm sorry, Lauren, can you clarify, can I just ask a follow-up question to clarify?
Yeah.
Are you asking as a matter of the US First Amendment or as a matter of the way that I'm
the US, because I think like, because especially these social media companies are American, that's where the regulation will most likely start.
Yeah, so I think, let me answer the question and then fight a little bit that last point that you made. I think if a regulation focused upon or required the or prohibited posts that contained links, URLs, as opposed to merely text. So I worry, first of all, that would be under-inclusive with respect to misinformation in ways that would make it ineffective. So you know, the person who links to, I mentioned in the story, there was a story that went viral about how Elizabeth Warren, who's the senator from Massachusetts, former presidential candidate, there was a fake story that she had dolls that were blackface dolls in her kitchen. And how anyone knows what's in Elizabeth Warren's kitchen is kind of weird. I don't know. But this story goes viral, right? And I presume it goes viral through links. But then, so in a world in which links are not permitted, people are just typing in, I hear Liz Warren has, you know, such and such in her thing. So I'm not sure that the prohibition on links would do very much. The other reason for thinking that the prohibition for links does not do maybe the work that you would hope it would do is, so my understanding of the violence that occurred around the 2007 Kenyan election, right? Where, do people know that? Kenya had an election in 2007, there was an immense amount of ethnic violence around. And the ethnic violence was driven by mass communication technologies. And in particular, it was driven by people texting. Like, oh, X group, and I'm embarrassingly unfamiliar with the different ethnic geography, the ethnic geography of Kenya. But X group has, you know, attacked our group, right? The two people who just ran for president of Kenya were on different sides of that ethnic divide, right? The ethnic violence that occurred in Kenya happened because of people texting, this has happened to me, or I've heard that this has happened there. They were texting, they were not using links, and it was almost 15 years ago. That suggests that that's not going to be that effective. But I do think you're right to say that either the companies themselves or the regulators of the company ought to be thinking about granulating, right? Cutting more final species of regulation that they're doing. I suspect that the first line of attack here is a redesign of the algorithm that manages something like the Facebook feed, right? And there's some evidence that Facebook did change their algorithm well, they said they changed their algorithm in 2020 out of concerns about misinformation around the US election. The news reports suggest that they unraveled those changes in early 2021 because although the changes were effective in reducing the spread of misinformation, they also reduced engagement. So the commercial incentive on the part of Facebook to maximize engagement trumped the interest in minimizing disinformation or misinformation. So that may be a case where there's actually a tweak that's relatively modest, that at least the core extent, Facebook has 70% or so of the social media market. There may be a tweak that's actually relatively easy that the company itself won't do because of its own market-oriented incentives, but that maybe the state can come in. Of course, the problem is that the US state can't do anything. It's you know, more or less paralyzed at the national level. So I think that's where that's how I take your question and turn it slightly on its side of it. The last thing I would say is, you know, I wouldn't underestimate the power of other actors to regulate in meaningful ways. The EU's, both the General Data, the GDPR, and now the Digital Markets Act, I think are potentially important measures, regulatory measures, which I think have had less effect than they could have because of the way that they're drafted, rather than because of the weight that the EU brings by dint of the size of its market. I do think you're right that there are other entities, and probably Canada falls into this category, where it would be much harder to regulate. So in 2020, Australia was considering a regulation of the news of social media platform, right, aimed at disinformation. And Facebook, in response, turned off its newsfeed for the entire country. The Australian government withdrew the regulation within a couple of weeks.
Wow.
So that suggests that, you know, if you're Australia, probably if you're Canada, yeah, good luck with that, right? EU, probably, they just need to draft things that actually make sense, right? And then the US I think is probably I don't know what your rules are about. If I'm happy with thought, but you should.
Yes, no, please.
Sorry, go ahead, just quick follow-up. Do you think though, I mean, this is just a guess, but do you think if they had gone through with that legislation in Australia, would Facebook then have been like, well, whatever, now we have to fall in line because we're losing out on all this economic interest? So it was just like a kind of a game of chicken, and if they had just followed through.
Yeah. So at the same time that Australian regulation was going on, there was a process that was beginning in New Zealand toward the development of a self-regulatory code with a third-party overseer to determine whether the code was being followed. That code was released relatively recently. It was earlier this year. And one way of thinking about what was going on in Australia is that Facebook was playing multiple tracks at once. So they were pushing back on regulation, but they were pushing these self-regulatory instruments. The self-regulatory instrument, the one that comes out of the New Zealand efforts, my understanding is that it's not precise enough. It's too vague to have much of to have a likely impact upon the harms, be they disinformation. I think the New Zealand concern is motivated by the Christchurch killings, and so it's very much also focused upon hate and hate speech. It's not clear that it's going to be effective enough. But your point that, could Australia call Facebook's bluff? I think the answer is yes. It'll be interesting to see what happens with Texas and Florida. South Carolina, in the wake of the decision of the Supreme Court on abortion, Dobbs, the legislature has introduced, I don't think it has passed, a law that would prohibit the dissemination of information about abortion on social media platforms. So I don't know, if you're Facebook, do you comply with that, or do you just say, sorry, South Carolinians, whatever they call them, Carolinians. I used to know this, I went to university in York. Sorry, South Carolinians, you just don't have access to Facebook. Yeah, that would be interesting. I doubt that's going to happen, but yes, you can imagine that.
I see Professor Lawrence was next in line.
I'm Sandra Lawrence. I'm not a professor.
I
know, I'm far. So I have one question. I thought I had two, but you've answered the one about that's around the commercial interests of these particular entities and how that might be different from some of the other potential threats that Loan Scheme was thinking about. But I think in the Canadian context, this talk inspires me to maybe go back to see what's happening with our large-scale platform regulation efforts at the federal level. So hopefully there's someone here who can comment more on exactly where we are with those right now. And in the Canadian context, these are significantly based on harm, right? And that's because of the way that our constitutional freedom of speech works, where government attempts to regulate speech that are based on attempts to prevent harm, particularly to vulnerable groups, are much more likely to be upheld under Section 1 of our Constitution, which allows some limitations on rights. So the question I have now is the examples that you're providing appear to be examples in which the harm is very directly aimed at a political system. And the question that I have is around the way that the Canadian court, for instance, has traditionally maintained its distinction between hate speech on the one hand and political speech on the other hand. And in teaching first year constitutional law, one of the points that you always want to make is hate speech is so profoundly political. So from the point of view of let's say feminist activists who have been thinking about the attempts to regulate kind of platforms because of misogynistic that speech that has high traction, like you don't want to really think about it. Let's think about it. Where does that fit into the kind of regulation you're talking about, where the impact on the political system is slightly diffuse and maybe often not necessarily recognized in the same way that something like let's get together a mob to attack the Capitol on January 6th is the clear much clearer to us. But attempts that kind of gradually attempt to remove certain groups from any political speech of their own or political legitimacy seem a little bit more diffuse if they fit inside what you're proposing or not.
That's a terrific question. Let me give one answer about the US, and then let me raise a question about the Canadian framework, which I don't know about, but I'll raise it because I find it interesting. I find your comments fascinating, and I'd love to hear more. So I think the way of conceptualizing the threat, the way that I and my other writings on democracy have conceptualized the threat to US democracy, at least, is in terms of the idea of populism that the political scientist Jan Werner Müller has now quite famously elaborated. And Jan defines populism as a moralized style of politics that juxtaposes a cohesive whole, a nation, which the politician preemptorily speaks for without any kind of electoral mechanism mediating that. I alone speak for the nation as the sort of the quintessential version of that, but that opposes itself to an impure other. And I think that that's a powerful way of thinking about populism. It's a way I think that Jan would say is influenced by a thinker from the 1930s, Carl Schmitt, who defined politics in terms of the politics is only the delineation of the friend versus the enemy, and the enemy must be defined in mortal existential terms. Right? He writes that in 28, sorry, Concepts of the Political. So I think that Jan is drawing upon that. I think in the United States, the friend is defined, or the people is defined in, it has come to be defined actually less in racial terms, but in cultural and religious terms, where the core of the religious identity is a particular form of Christian nationalism. And given that structure of populist logic, as Lowenstein predicted, there are going to be a set of what he called agitations, that's his word, with respect to minorities or outgroups in some way, shape, or form. And I would count women, even though they're not a demographic minority, right, as an outgroup who are asymmetrically exposed to several forms of distinctive violence. There are a number of different kinds of speech that I think would be classified as hate speech that fall into that category, or that are adjacent to the project, or instrumental, or amenable to being instrumentalized for the project in a way that puts them underneath my rubric. But the key to deciding what's in and out is the conception that I'm offering of the style of populist politics, right? And I do think religion has in a way that has surprised me, religion has a kind of significant role in this formation in the United States at the moment. So it is not, you know, I think if you had asked me 5 years ago, you know, can you imagine a significant national somebody running for a significant office, political office with national significance in the United States being openly anti-Semitic? I would have said no. I can imagine sort of dog whistle racism. I can imagine Islamophobia, but it's, you know, for very good reason, and thankfully, anti-Semitism is off the table. That's not the case today. Doug Mastriano in Pennsylvania is openly anti-Semitic. So I think that what's going on there is a resurgence of a particular form of Christian nationalism. So that I think is sort of my answer internal to the theory that I've offered. So in the context of the Canadian jurisprudence, the question that comes to mind goes back to Mill, right? So Mill, John Stuart Mill, progenitor of the harm principle, defines harm, right, by saying it's something that damages somebody else. But of course, there's now this sort of long literature going back to Amartya Sen's famous piece about Barresian liberal that makes clear that we don't really know what counts as a harm to somebody else and what's not a harm, right? If, you know, in Sen's famous example, if I'm sitting at home reading Lady Chatterley's Lover, am I imposing a harm upon the religious person who is shocked and horrified that there's somebody reading Lady Chatterley's Lover, right? Well, you know, there's no way of using the word harm to answer that question. Where do I go with that? Where I go with that is, I would want to hear more about how Canadian courts take an idea of harm, which I think is non-self-executing, see the critique of Mill, and then give it meaning, and then draw distinctions, as you say, between different species of harm, right? None of that seems to me obvious, or none of it seems to flow from the idea of a harm ex ante. And I want to know a little bit more about how, or it's intriguing to think about, like how those steps of liquidating this inchoate concept play out.
Just to be clear, I don't think there are a lot of gaps between the different versions of harm that the Canadian courts suggest, and also Section 1 obviously offers things other than harm that can be used to justify government limitation of rights.
Can I ask a question? Or which, I mean, if it's not for you, it's
I'm saying yes on behalf of my colleague.
so let's say that the government, a provincial government says we're going to do this because of the harm to the democratic system. Would that count as a Section 1 harm?
You could, I think you could relatively easily make arguments on that basis.
But there isn't a decisive ruling on that.
Well, it would depend on, I think it would depend on whether it fit with the other kinds of things that fall into that box. But yes, and
Okay.
depending on the context, because Section 1 is entirely contextual, which produces a lot of this uncertainty in this area. But yes, you could definitely start from that.
Hi, thanks. I'm Dan, I'm a teacher. So there are lots of questions, and I'll just ask one, and if there's time, I'll come back. So I want to focus on your last point about sort of comparative institutions and so on. And so I will make an observation about the US, which is sort of anecdotal, but I think it's not completely wrong, which is that one problem that may be difficult in sort of importing these ideas from, say, Germany, or even Canada, is the sense that non-political expert institutions are an idea that's accepted in some ways in Europe, and I think even to some extent here, to an extent that strikes me as a sort of, you have to be absolutely naive to think that that's possible. And so to give an example that actually may be not too far away, because it relates to questions of democracy, think about districting of states or provinces. So in many countries, there are bodies that are accepted as broadly non-political that manage to do a sort of okay job. Of course, it's not perfect, and yes, there are political influences and so on, but within the limits of human nature, they do a decent job. Whereas from what I read in the US about the bodies that deal with districting or redistricting, it's completely rigged. And if you try to suggest, oh, let's have a non-political body that did that, either people would laugh at you, or within 2 years, it would break down and become politicized again. And at some level, you could say this even about courts themselves. So again, no one is completely naive to say, oh, courts are, law is completely separate from politics, and no one believes that anywhere, I think. But the sense that
some of my colleagues believe that.
But the sense in which you can have some level of non-political legal argument say in England, in the Supreme Court there is much more deeply accepted than the context today of the US. So to the extent that you want to say, okay, I'm with you, let's go ahead with this. And we say, okay, next step is to build this body, and it will just not work in the US context in the way that maybe it can work in, say, in Germany.
Yeah.
I'll ask the second question, which is really kind of very simple. So you draw sort of on German experience and others with this idea of militant democracy, but on a simpler level, maybe too simple to be worth writing an article on, which is why I didn't. So Germany, as far as I know, has actually been more aggressive at regulating Facebook and other social media. I don't know if it's part of a conception of militant democracy, but just because they're not absolutist about free speech. So why not say to Americans, look, if you think that if you make any kind of limit on free speech, ipso facto, immediately democracy is ended. Well, let me share one example of what looks like a functioning democracy, not a tiny country of 90 million people. They have restrictions on free speech, and it still remains a democracy. So,
yeah, I'll do the second point first. Those are terrific questions. So I always have this moment of cognitive dissonance when I teach American constitutional law, and we get to the separation of powers, and some student trots out the normal explanations that, well, unless you divide government, the necessary result is despotism. We know that from Madison. Maybe if they're really smart, they'll say we know it from Montesquieu. And I'm like, wait. I grew up in a country in which the executive is drawn from the legislature, and where, at least until 2005, the highest court in the land was a bunch of old guys in wigs who sat in the House of Lords. Maybe incompetence is the simple answer to why England is not a despotism, but it's not, right? So I absolutely understand where the question is coming from. I think that what you're pushing on in that second question is the deeper parochialism of American A, jurisprudence, and B, scholarship, particularly when it comes to the First Amendment. And I agree completely. And the project here is very much to deal with that by essentially ignoring it and then going off in a different direction. So I'm very sympathetic to that. So I think that the first question is really I think a good challenge. And I think there's two versions of that question. The first version is that it's so hard to get an independent institution off the ground that in the United States that we're not going to be able to make it work. Right. The second version of the question is the independent institution will come under such ferocious partisan attack that it will break down. Notice that those are one is a supply point and the other is a demand point. So I think the supply point, I think there's mixed evidence for it. I agree very much with your argument about courts. I think so. Palmer kindly mentioned the book that I wrote last year. And the first half of that book is about why judicial independence in the United States has broken down. Right, why we have partisan courts, and it roots it in the design of the federal courts. Right, Canada did not make the same mistake. Many other jurisdictions did not make the same mistake, and therefore they have much better functioning courts that are able to keep a distance from politics. Even the UK Supreme Court, which came under tremendous pressure as a consequence of two decisions, Miller 1 and Miller 2, that came out of Brexit debates, still managed to keep its distance from, or managed to keep itself out of partisan politics in the way that the US Supreme Court hasn't. So I think that the problem with the US Supreme Court is very much one of design. I'm a little more optimistic, at least now, about the supply side with respect to districting, because there are a number of independent districting commissions that are nonpartisan and that seem to do a pretty decent job. Michigan's does a pretty decent job. New York's does a pretty decent job. Well, New York has a judicial review for partisanship in districting. Now, all of that may go away because of a decision called Moore v. Harper that the US Supreme Court is about to hear and decide upon, which we could go down that road, but Moore, if it were decided a certain way, would terminate that. Moore is an example of the second point you make, which is as soon as you have independent institutions, they come under a great deal of pressure. I think that that is right, is correct now in the United States. I think the Moore case, which is really is a challenge to anything other than full-throated partisan gerrymandering, is essentially a kind of historical claim about what the Constitution means that people have made up out of whole cloth in the last 3 or 4 years, and that is sympathetic or simpatico to the Republican-appointed majority of the court, and so it'll probably become law. Right, that's an example of push on the demand side. You see now a range of attacks similarly on independent producers of knowledge. So Florida has a statute that prohibits teachers and university professors from saying anything positive about LGBTQ identity. Right? Don't say gay is the name of the law. It directly is an attack on universities. The Brookings Institute, which is a milk-water, middle-of-the-road think tank in Washington, D.C., has come under attack in the last week for being partisan. Right, as if the American Enterprise Institute or the Heritage Foundation are not partisan. So I think you're absolutely right. Any kind of effort at being an independent knowledge center or being a kind of autonomous entity that makes judgments based upon non-consequentialist, non-partisan consequentialist reasonings comes under tremendous pressure. Oh, the attacks on Anthony Fauci, who was the sort of the czar of COVID response, is another example of this. What's all the same thing? This is a relatively recent phenomenon in the United States. It's something that's happened, it's essentially a post-Trump phenomenon. And I think Trump has, rarely is it the case that individuals make a big difference, right, that change the nature of structural politics. I actually think Trump has changed the nature of politics in the United States by licensing certain kinds of behavior that were beyond the pale previously. And I think what you're describing is a set of behaviors that have been licensed in the last 6 years. I think that the takeaway from that is that you're exceedingly unlikely to have certainly a governmental entity that can play the kind of role that I'm describing. And that any private entity that does it, Facebook Oversight Board being the leading example that we have, will quickly come under a tremendous amount of pressure. And we're seeing that's the Florida law, that's the Texas law, right? So absolutely, you're totally right. So I think there's 2 ways in which you can draw inferences from your question. One is America is too far down the road. That might be right. It might be the case that it's not too late, except for us, right? That just might be the empirical truth of the matter. The second is maybe there is a marginal comparative advantage for private as opposed to state entities because they're able to claim, for example, First Amendment rights. And it's very hard now because of the rigidity of the doctrine to totally do away with those. So I can see truth in both of those, that it's too late. And maybe at the margin, private entities are a little bit more immune from the forces that you're describing. But I think that trying to predict which of the, trying to figure out which of those is the case is very, very difficult.
Yes, my name is Ishan. I'm a 3L student. And kind of just to touch on your last point, I kind of wanted to hear your perspective of, I know that you laid out those 5 key kind of points and a bit of a framework, and I wanted to hear, I know that you said also that really the First Amendment in the United States made it very difficult to implement any of those recommendations, those 5, but are there some openings there? And I kind of relate back to the idea that I read a book, Save the News by Martha Menow, and she describes the idea that the First Amendment, yes, has become a tool that's like been used to pretty much take away union rights, take away employment rights, and many other things. But back in the past, with things like the Fairness Doctrine and the Federal Communications Act, they were able to regulate it to a certain extent. She calls for that somewhat regulation in order to, in many ways, what she describes as save the First Amendment and then also save democracy. And so I wanted to hear if there was any way that we could potentially implement some of those 5 recommendations.
Yeah, I tend to be more skeptical than, I can't really call her not, right? Like, I've met her like twice. It doesn't count. Professor Minow, Dean Minow. I tend to be more skeptical than Dean Minow of the potential to reverse the doctrine. I think that the doctrine for the reasons that I alluded to, which is that the porousness of the federal courts in the US to partisan influence. I think they've become porous in a way that they haven't been porous for about 160, 70 years. I think that asking the court to do better on the doctrine is a fool's game at this point in time. I think that, or it's not likely to bear fruit. I think that the more likely avenue is to focus upon the idea that the platforms themselves are First Amendment rights bearers, and as such, because they curate and design their own platform experience, have a First Amendment interest in deciding how that's done. And I think in the comparative analysis where I am, and very much the paper's purpose, to be clear, is not to sort of say this is how you should come out. It's to say here's how you should think about it, and then you bring your own empirical bias to the project, and you come out the way you think is best. But going beyond the paper and saying where I am, I tend to think that the Facebook Oversight Board, for all its problems, is probably the best we'll get. Right, and I think I am very much a don't let the perfect be the enemy of the good kind of person. That's my temperament. And so I think that the more space that can be preserved for that kind of effort through the First Amendment, probably the best. But I absolutely will concede that that doesn't follow from the paper. And you could bring a different set of judgments, normative or empirical, to bear and come out in a different way. Thank you.
Just a reminder to those joining virtually that you're very welcome to send your questions directly to me by chat, if you'd like to do so. Just glance around and see if anyone else joining us. Mr. Nathan, thank you.
Thanks so much for the talk. It was me, yeah. Okay. I'm Jennifer. I'm faculty here. Thanks so much for the talk. I just wanted to say that my initial reaction to hearing you talk was, or just the nature of your talk, it was not so much, although social media is obviously a problem, but I was just struck by how much you were pointing out the fragility of democracy. And so, I mean, and like as the architectonic ideal, like it just seems so weighted with contradictions, and that part is nothing new. And so partly I wondered, would you want to distinguish between the harms of social media that would be harms? They're not, the harm of misinformation seems to be a harm. That's not necessarily a problem for democracy, but it's inciting violence. These are things that we could respond to with regulation. But when you're pointing to the other problems, the idea of certain parties arising that, and what if they all just elect a dictator? Like, these are problems inherent in democracy. And maybe it's too naive to suggest that the problem there is to, rethink whether democracy is the architectonic ideal, or should we actually be thinking of the rule of law, for example, as the architectonic ideal, because then, regardless of the party, then there's just only there's limits to what they could do. But that's sort of problems with democracy and whether we should be elevating it necessarily in the way we do. And then I would sort of regard that sort of worry as different from worries about misinformation, worries about inciting violence. I wondered if you wanted to make that type of distinction, or you see it as all sort of the same sort of problem.
That's great, thank you. I'm very sympathetic to where the question is coming from. There's no way of to give flesh to that. I'm just going to cite things that I've written in the past, which exemplify or echo points that you've made. I mentioned that I wrote a book which came out of a 2017 law review article on the legal mechanisms of democratic backsliding, and recognized in the course of that book the way that in many instances, and I think Hungary is probably the best case, or the case where this is the clearest, legality, so in many ways the rule of law, and otherwise perfectly licit measures can be linked together in various ways to unravel democracy from within, right? And so the project of that book was essentially thinking about how you prevent that internal unraveling from happening. One of the side projects that came out of it was a political theory paper for Nomos that was called Democracy as Failure. So, and the idea of that paper was there are all of these ways in which democracy either internally contains its own unraveling or propagates dynamics that over time destroy itself. And the paper was an effort to kind of think through those as a matter of democratic theory and think through, well, once one recognizes these internal contradictions, well, what's left of the idea of democracy, right? And I don't give up on the idea of democracy. I just write in that paper. I think that, but I think a mature version of the moral commitment to self-rule engages in and recognizes and struggles with the difficulties and the tragedies of it. And then because I wrote this book, The Collapse, I was talking to people at Oxford University Press and ended up literally on Sunday, finished the first draft of a book for Oxford on the rule of law. They have a series called Very Short Introductions. They're really cool, except for mine. They're really cool little books. They're like this big. They're like colored, brightly colored. They're like $10 in the US, and they're like 130 pages on a topic. It's great. I was reading one on algebra because my son is learning algebra. It's like, oh, I should learn about the history of algebra. So it's like, you know, it's like you can read it in 2 hours, and it's like a history of such and such. And so I'm doing one on the rule of law, and part of that is about saying the rule of law is as a term that people use, but that turns out it's an umbrella concept that has a whole slate of variants on it. But the book ends with the last chapter is about how does the rule of law come unravel, right? And one example of that is Hungary. The other example is China, where China has since about 1997, China has recognized the rule of law as a constitutional principle, but increasingly used it as or aligned it with the principle of not state control but party control of the state and party control of society. So that's a kind of the rule of law is doing something very different in China and Hungary than from here. So I'm very sympathetic to those points. I think the defense in terms of this project is to say something along the following lines. It's to pick up on your use of the term architectonic, right? The idea that, look, policy faces lots of problems, but in the absence of a baseline capacity to recognize a problem, in as much as something that imposes harms on a substantial number of people, not just some people, but generally, and respond to that harm, right? That capacity requires a certain kind of democratic responsiveness. And so there is a sense in which democracy is prior to, or the capacity for democratic responsiveness is prior to the capacity to respond to all of those other problems. Right? I don't think it's a complete answer, but I think it's a plausible first approximation that justifies, at least in the project context of an academic paper, foregrounding democracy and saying, look, I'm going to focus on democracy. I'm not going to focus, for example, on the issues, the real and really important issues that people like Danielle Keats, Citron have written about the harms to women in particular of hate crimes and sexual and stalking. So I also don't want to suggest in any way, shape, or form that those are not extraordinarily serious and important problems.
Perhaps I'll ask a question if I may, because I don't have any coming through in the chat, although I will keep an eye on it in case anybody joining us virtually wants to share a question. And I may be taking us quite far from the core of the paper, but it strikes me that when we're thinking about negative or bad impacts of social media on democracy, there's the most obvious is Sonia made the helpful distinction where there's a direct, more or less explicit attack on democratic institutions. There's concerns about harmful speech, and we've talked about the ways in which that can be a challenging term to concretize, but speech that is directly aimed at or indirectly, subtextually aimed at vulnerable groups. And then it strikes me that another possible concern is where the speech itself is not intrinsically harmful, nor is it incorrect, but it's been curated or selected in such ways to create a distorted picture. So, you know, we hear sometimes about how social media can create or amplify echo chamber effects, right? So I can imagine if, you know, the only media that I was ingesting about vaccination was about verified stories of people having negative reactions to the COVID vaccine, those stories may be independently true stories, right? Unlike the Elizabeth Warren stories, but they're curated in such a way as to, you know, is to amount to misinformation that then was going to undermine my ability to participate as a, you know, within democracy as a voter in the way that we would hope that voters would behave. But I'm curious as to, I mean, seems that if we're doing something like mandating quote unquote balanced speech, and there's all kinds of problems about defining what that is or fetishizing the idea of balance, right? But it seems like we're mandating speech as a whole other level of problem, both from a First Amendment perspective, I assume, as well as in terms of the theory here. I'm just wondering if the militant democracy theory or your sort of broader interventions can speak to that dynamic, or if it's fair if it's just beyond the scope, because we're already asking you to do a lot of work to save democracy.
Not exactly doing a good job. I do think that there is an analogy between what you're describing as a problem in the context of social media, problem in the original party context that militant democracy was applied to. In that first context, Lowenstein recognized that there was a boundary drawing problem, that in order to determine what parties were amenable to that, you have to figure out which were the word that's now used in political science literature, which he didn't use, but is useful here, is anti-system parties. What are the anti-system parties and what are the not anti-system parties? And it turns out to be really hard to draw that line. Lowenstein's version of the line was, well, does the party appeal to emotions or does it appeal to people's rational interests? Now, I don't think that distinction that Lowenstein drew survives even a moment of critical reflection, right? So he doesn't draw a line effectively to say that this is what the boundary is. And the way that the term is used now, it is unclear unless it is understood as essentially the disposition, the belief that a competitive system of elections or selection of leaders is acceptable, right? Do you believe that it's acceptable to have rotation in power, or do you not believe it? And that turns out to be really hard to implement. Do we think that Giorgia Meloni, the new, at some point she'll be the premier of Italy, prime minister of Italy, right? Is she predisposed to accept the legitimacy of rotation in power, notwithstanding she's the leader of the party that stands in lineal succession to Mussolini's fascist party? I don't know the answer to that question. It's really hard, but I do think it's the right question. Here, I think that the analogy to that, or in the platform context, the analogy is, I wouldn't draw a distinction, I think, between partial versus false, partial truths versus false truths. The vaccination example is a terrific one, right? I wouldn't draw a distinction between, here are these cases of bad side effects, or the vaccine is actually injecting a microchip into you that the government will use to track you, right? Those two, they're formally distinct. What I would ask is, does the actor demonstrate a commitment to the value of truthfulness? Now, truthfulness is, I talk a little bit about this in the paper, is a term of art that the late philosopher Bernard Williams coined in his book Truth and Truthfulness, where he said, look, you can have people who are, you can ask, do people have a disposition toward, an orientation toward getting the facts correct, an orientation against error, right? In the way that they proceed, in the way that they speak, and the facts they offer. And just like the anti-system disposition, truthfulness is a vague term, and it's capturing something that is internal. It's a psychological state that is perhaps problematic when transposed onto a corporate entity, right? One way of thinking about that transposition, though, is to say, well, it turns out that Facebook knows well the changes it could make in its algorithm that would minimize misinformation, minimize the spread of posts that conduce to political violence. And it chooses not to do that because that would bend the curve of engagement and lower its expected revenue from the sale of personal data to behavioral advertisers. And as such, observationally, whatever it is that Mark Zuckerberg believes, observationally, we can deem Facebook not to have, at least in that moment, a disposition toward truthfulness. I think that's the best we can do, but I want to recognize that the problem, I fear that I'm just restating the problem that you just described, but I'm giving it a label, and the label is sometimes helpful, but the label is truthfulness is pretty vague, right? And it doesn't have the kind of crispness that we lawyers want it to have. But I do think it's the right label. It's just that it's really hard to make precise.
I'm just glancing around, see if there's any final questions, comments. Oh, please go ahead.
Yeah, I have a comment. So I'm a PhD student, a second year in socio-legal studies here at York University.
Right.
And I'm also a Nathan Fellow, so a fellow at the center. And I was really intrigued by all of your arguments, and it made me particularly think about the Canadian context. When coming off of what Professor Lawrence had stated about the current notion of hate speech and how that plays out within our current context. And I was thinking about the introduction of, I don't know if you're familiar with Bill C-36, which was a provision that was introduced by the Trudeau government recently, that is supposed to curtail online hate speech or introduce legislation that curtails that. And it's a revived notion of Section 13 of the Canadian Human Rights Act, which was repealed by a previous government in 2013. And so this is a new piece of legislation that's supposed to add to the notion of what human hate speech is defined under, and also help complainants be able, so the public be able to make complaints against online hate speech to various platforms, so those like websites who perpetuate the hate speech. But there's been a lot of debate and pushback, of course, against this introduction of this bill. And it was really interesting that in public consultation this year, the same groups or the same different sectors of society that people feel that hate speech reflect disproportionately, LGBTQ, racialized communities, Indigenous people, were also the same communities in public consultation. So coming back to this notion where you present as that double-edged sword within democracy with the notions of regulating online hate speech. So the same communities who came out and say we are going to be disproportionately curtailing our freedom of speech within these platforms because of the introduction of this bill that is also supposed to be helping us.
Yeah.
And I found it so fascinating of this notion of how, when you talk about the notion of how Texas and the leftist notion versus the right notion of how these legislation and regulations are supposed to be implemented, what it says about society and democracy as a whole, the direction that's going in various areas. So it was just a comment and thinking about the Canadian context versus the American context. But I really feel like the timeliness of your arguments and the article that you published, that it's really interesting in relation to the Canadian context and this new legislation that's being introduced.
That's fascinating. Thank you very much for the reference. I'm going to look it up. One thing it makes me it brings to mind is in an earlier book I and my colleague Tom Ginsberg argue against militant democracy in the political domain on the ground that's very similar to the one that you identified, which is that particularly in France, which has a raft of kind of associational measures, they can disband associations and prohibit certain people from speaking. Those measures have been used largely to target the Maghreb minority in ways that, once one knows a little bit about context in France, look awfully like the complaints that you describe in the Canadian context. It offers an example of how those complaints could work out or be very, very real. And our conclusion in that context was to say, the track record here is really sufficiently poor with respect to speech bans and association bans that we think that, first amendment aside, we should avoid them. And it was exactly on the logic that you described. So I think that the French context may give you also some grist to think about the scenario you're thinking about.
Go ahead.
So I'll go second time. I don't know if you, I unfortunately I did not see the published document, so I don't know if you talked about this, but so you describe the origins of the militant democracy idea, and you say that Kelsen found it kind of contradictory. And I must say that I have some sympathy to this suggestion in the context of limiting participation, because, well, to take a most extreme example, imagine that there is a vote in which a majority votes to stop democracy. I see it very difficult to say, no, we will not, from if you believe in democracy, you kind of need to accept it. Now, however, I think in this context of speech regulation, it might be an easier move, but it might require you, maybe you do this elsewhere, maybe in this paper, to get into the question of free speech justifications. Why so? So if you say the real reason, so there may be all kinds of reasons why we like free speech, but the reason why it's constitutionally protected is for the sake of improving democracy, for example. Then you say, when I have good evidence that undermines it, then for militant democracy reasons, I'm justified in doing so. If on the other hand, you say, no, actually the real justification of democracy is, individual autonomy and self-expression and all that kind of stuff, then it's more difficult to then come and say, oh, for the sake of democracy, we should protect it, because someone will say, well, that's not why we have free speech. Yeah. So it's not impossible. It's sort of easier to say, I think, on the first story. And so I wonder to what extent you do, or you think you need, or you want to get into the question of free speech.
Yeah, no, I think that's great. I think that trying to do that in terms of the US free speech tradition is not the way that I would go. In part because the free speech tradition in the US has a kind of an excess of explanations or justifications for democracy. There's a democratic justification associated with Meiklejohn. There's a kind of self-realization justification that's associated with, I think it was Emerson. And then once one turns back to the 1791 origins of the First Amendment, the evidence there is that it had a very, very limited conception, just priorist rights and maybe a couple of other things. And was pretty, the framers didn't have that thick, the US framers didn't have that thick a notion of democracy. And it's certainly not a version of democracy that I'm comfortable ascribing much moral weight to, given how much of the world it excluded. I do think you're absolutely right to say that there is a need for a thicker version of democracy to be offered as an anchor point for the argument here. I'll go back and look and see how much I said about this there. In other work, I have described democracy as not reducible to majority rule, but rather as an intertemporal project, a project that stretches over time, where you commit to being ruled or being ruled over time. It's a sequential project where you accede to the possibility of flowing in and out of power. The rule and be ruled over time I just stole it from Aristotle, but it's a pretty good definition. It's pretty good because and this we're getting very far from the paper. It includes not just elections, but it includes sortition. So I am of the view, and there is a passage in our book, the book that Tom and I did, which takes this position, but nobody has picked up on it. Maybe thankfully, because it's a bit crazy. that elections are inferior to sortition mechanisms as a device for realizing democracy, like picking by lot randomly. I think that it's a much better mechanism. I think that elections have many, many structural problems and are unnecessary for the realization of meaningful self-rule over time. So that argument, which is buried in a paragraph, is too extreme in the US Legal Academy, and I would not want to be in.
Dworkin was also not like minimalistic on the majority.
Yeah, well, it's made. I mean, there's a political scientist at Yale, Helen Lansmore, who has made the kind of full-on. We should give up on elections are a bad idea. We should give up on elections and we should use various forms of sortition. I agree with Helen. I think that she's right. I'm glad that there's somebody out there who can write this in political science and, you know, has a tenured position in Yale. I think that if I said it, it would sound totally crazy, but I do think that I do have a quite distinctive idea of democracy, which I have articulated in a couple of places, and I probably need to say something more about it.
We are at the end of our time. We always think it's a great session when we're so full of questions at the end of time, but we are, I know at the moment where many of us have to get to our next class or meeting. So it just remains for me to thank once again Professor Aziz Huq for sharing this work with us. Thank you so much.
Thank you very much for the terrific question.